Hi, everybody. Thanks for having me back anyway. And thanks very much to the Department of Revenue for making this great facility available to us for this CLE. When Bill moved over to the Office of Insurance Commissioner, and he began participating in the network of adjudicatory agencies, I noticed in fairly short order that he had a very similar interest to mine in keeping up with what the courts were saying about this ever-evolving landscape. So I invited him to participate with me, and with his usual and marvelous enthusiasm, he really took this project on, and we have Bill to thank for developing and presenting virtually all the materials that you have in front of you this afternoon. So thank you very much. And I'm going to turn this over to Bill just after a couple of quick comments. One is that we do have a hard copy supplement of just a couple of cases that didn't make it into the materials that were already distributed. They should be making their way around the room. If you don't get one, we have some more, okay? And the second is, we're presenting these cases from what we understand from an outsider's perspective. There may be people in this room who have had some involvement in some of these cases or who know about them. And if you do, please don't hesitate to jump in with any, to share any experience or insight that you may have about these cases. We would appreciate it. Thank you. Bill.
Good afternoon. We kind of compiled and read through about, I think I read through over 100 cases, just kind of cut it down to the ones that I thought were essential, at least that I share with the group, that I thought were interesting enough to share with the group. They had some kind of rules from the cases. And most of them are primarily APA based. For a while there, I was looking at Public Records Act cases, and I said, no, we can't. We have to scrap that because there's just too many cases. That's a specialized area. It's not really administrative law. It's a specialized statute, 4256. So I'm going to talk about, kind of in my half an hour, 40 minutes, 13 cases of the materials that you have in front of you, 13 cases I want to highlight that I think have some important rules and takeaways you can take away from the cases. The first one I want to talk about is on page 8 of your materials, Tri-City Railroad Company versus the UTC. This is a published case. That was one of the challenges too, is tracking some of these originally said they were going to be unpublished, but they eventually turned out to be published because one of the parties asked for it, or the court agreed to that, stipulated to it later. And then some of them said they would be published, but the sites would come along online later, so you had to kind of track it on Lexis or Westlaw, whatever your choice was, just to kind of keep track of what the sites were. The first one is Tri-City Railroad. This was a case about an at-grade crossing. What the issue in the case was whether or not the UTC correctly decided that an at-grade crossing in the cities of Kennewick and Richland was legally justifiable. And one of the issues that the UTC had to consider was the impracticality of making a tunnel or a bridge across the railroad. Now, many people might not know the UTC has to handle is the authorizing authority for this particular area of law. It's 8153.020 RCW. The rule from the case that I thought was significant is the Court of Appeals Division 3, in doing their analysis, stated that where a statute dealing with the administrative agency's duties and operations is ambiguous, we must also consider the possibility that a statute's ambiguity constitutes an implicit legislative delegation to the agency to fill in the statutory gaps. And in filling in the statutory gaps, this includes effectuating a general statutory scheme, including through statutory construction. Now, I thought the court was being very generous there to the UTC and interpreting their own statute and their authority, but I thought that was a good rule to take away from at least a Division 3 case. The court observed that UTC's duty per RCW 8153.020 to enter an order granting or denying the right to construct a grade crossing is standardless, apart from the legislature's general grant of authority to regulate in the public interest. That was the quote. The court noted that the UTC reasonably inferred that the legislature would expect it to give some consideration to the local concerns, planning concerns of the cities of Richland and Kennewick. And basically, that was kind of the linchpin in the case. They decided that the local concerns of the practicality of building the tunnel, given the low amount of traffic at this particular crossing, the practicality of building a tunnel or a bridge was so paramount that the UTC and the courts ultimately agreed that that basically they could take into account local planning concerns, and they approved the at-grade crossing. And basically the court said that safety was not the only consideration, even though that's pretty clear from the statute that safety is a pretty paramount consideration. The next case that I want to highlight is Hartleben versus the University of Washington. That's on page 12. This was an interesting case. This is one where the appellant, who had attended years earlier UW part-time, and I think it completed 5 courses or something along those lines. So basically a part-time student at the University of Washington. Basically, she developed some kind of depression, and then she had to have some treatment, and from that treatment, she developed retrograde amnesia. So basically, she forgot the content of the courses that she completed at the UW. And the courts, and one of her arguments, her main argument was to the school was, I have an accommodation, a reasonable accommodation that I want you to meet for me. That is for me to take tuition-free classes, to take the classes I already took previously tuition-free. And the court basically, basically the university said, and their offices said, no, we're not going to do that because we don't offer tuition-free classes even for people with disabilities. Went to the court. The court emphasized that the UW requires all students to pay tuition, and that appellant did not show that special circumstances existed to make it reasonable for UW to break this policy. The court held that UW's waiver of tuition for appellant would only address barriers she faced due to financial hardship and not those due to her disability. So under the Washington law against discrimination, they found that there was no violation by the University of Washington. I thought it was an important case. Some of you know about the case that recently went down to BIAA. I think it went into the trial court here in Thurston County. So, and the OAH is doing a model law on reasonable accommodation that some agencies are adopting, basically. And I thought it was an important case to kind of set the parameters of what a reasonable accommodation only goes so far. You can't make absurd requests that agencies don't provide all their constituents together. In this case, a student body. We're not going to give you tuition-free classes. The next case, which I thought was very interesting, from the Supreme Court on page 13, City of Lakewood versus Willis. This is a case where a police officer saw the petitioner walk into the traffic lanes of an I-5 exit ramp. Is it on? Yeah, basically the police officer saw the petitioner walk into the traffic lanes of an I-5 exit ramp carrying a sign that he was They give him precedent? Was supposed to be a red light? Okay, basically, the police officer saw a petitioner walk into the traffic lane.
There's another mic right behind you. You might try it. If the battery's weak or something.
Take it out. Has we hooked up to the same unit, or? Okay, this one works. All right. Can you hear me now?
Yeah.
Okay, sorry about that. City of Lakewood, Supreme Court case. A police officer saw a petitioner walk into the traffic lanes of an I-5 exit ramp carrying a sign that he was disabled and needed help. The police officer eventually issued him a criminal citation for begging. There was an anti-begging ordinance in the City of Lakewood. Now, this case, you might wonder, why am I citing to a City of Lakewood case? It's primarily because of the use of language, very important in ordinances, statutes. I don't know why this is humming. Ordinances, statutes. Now, the word "at" was very important because the anti-begging ordinance talked about prohibited begging at on-ramps of intersections, arterials, and off-ramps. A jury found the petitioner guilty. The petitioner appealed to the Superior Court, arguing for the first time that the city ordinance violated his First Amendment right to free speech and was unconstitutionally vague in violation of the 14th Amendment's due process clause. The Superior Court affirmed petitioner's conviction because he was seen in the off-ramp. That was important later on because the Superior Court convicted him basically because they saw him in the on-ramp. The problem is the statute said at the intersection. And that's going to be the problem for the constitutional analysis. The Court of Appeals confirmed petitioner's conviction, asserting that petitioner was convicted of begging on a freeway off-ramp. But neither the Superior Court or the Court of Appeals noticed that the words they were using in and on were not the statute. The statute that has written said at. Justice McLeod's opinion, joined by 3 other justices for the Supreme Court of Washington, noted that streets, sidewalks, and roadways are traditional public forums where the strictest free speech protections are in place. And the law protecting speech there must be content neutral and narrowly tailored to serve a significant government interest and leave open ample alternative channels of communication. The court noted that because the lower courts concluded that governments may restrict speech in a freeway ramp, they rewrote the ordinance. So basically what the Supreme Court does is that lower courts, you got it wrong. You were basically helped out the city of Lakewood by rewriting the ordinance to say that he was violating a statute that said in freeway ramps, when it's essentially the original ordinance said at freeway intersections, which the court ultimately decided was unconstitutional. The court reasoned that because there are sidewalks at most freeway ramps and major intersections in Lakewood, or any other city for that matter, the city ordinance covered many traditional public forums. As such, since the city ordinance imposed restrictions on speech based on content or solicitation for a particular purpose, i.e. attaining money or goods as a charity, the court therefore upheld petitioner's facial challenge to the statute. I remember Professor Meyer talking more about facial versus as applied. But they basically gave the petitioner the benefit of the doubt and read his briefing as making a facial challenge, even though really in his briefing he probably made more of an as applied challenge. And it reversed his conviction. Justice Stevens' concurrence agreed with the lead opinion's conclusion that the city's anti-begging ordinance was unconstitutional, but she would have gone farther and basically scrapped the whole ordinance, because she said that he was basically criminally charged under the whole ordinance, not just the part that essentially it was a severability issue. Can they take out the part that was unconstitutional, sever it off from the ordinance, and go on with the rest of the ordinance? And she said, no, the whole ordinance needs to be scrapped because he was charged under the whole ordinance. Justice Owen's dissent actually disagreed and was joined by 2 other justices. She basically said she would have done an as-applied challenge since the court did not have sufficient facts about the forms that were at issue. The dissent noted that it was an as-applied challenge as courts analyzed the specific circumstance of the ordinance's application to the particular conduct of the party. The dissent noted that freeway off-ramps where petitioners stood are not public forums and not for the free exchange of ideas, but rather the exchange of vehicular traffic. Since petitioner was in a non-public forum when cited, the ordinance only needed to be viewpoint neutral and reasonable in light of the forum. The dissent indicated that it would hold that the ordinance met both criteria because it takes no position on begging as expressing a viewpoint. And it was reasonable for the city to restrict pedestrians from standing on a freeway ramps to maintain safety. The ordinance was constitutionally applied to the petitioner. That's what the dissent said. But like Professor Theo Meyer said before, the dissent has more leeway and latitude to write a decision that's probably a little more pinpointed to the objection they want to make to the majority opinion. That's what happened here. The next opinion I want to talk about is City of Richland versus Wakefield, page 20. It's also a Washington Supreme Court case. I thought this case was important only because a lot of times as agencies we're going to impose financial obligations on people that come before us, and fines, whatever other obligations we can impose on them if we think it's legally justifiable. And the petitioner basically went to a fine hearing because she wasn't paying her monthly LFOs, legal financial obligations. So basically court fines. Petitioner had like a checkered history of addiction, and her parents were abusive, and she lived on Social Security and food stamps. The district court basically ordered her to participate in the work crew, the city district court, and pay $15 each month, even though she was only receiving Social Security benefits. She later petitioned to have those LFOs remitted under a state statute, RCW 10.01-164-4. and the court fines were remitted. Ultimately, the courts did not find that she had made her case. Ultimately, it went up to the Supreme Court of the state of Washington. And what's interesting about this case is even though the case was essentially rendered moot because all parties, including the prosecutors for the cities of Kennewick and Richland, agreed to drop the LFOs against the petitioner, the prosecuting attorneys of the cities did not find their legal position tenable. They still wanted the court to issue an opinion on, advisory opinion essentially, at the request of Richland and Kennewick on the LFOs against people that have low incomes. One rule that came out of the case in my mind was the court emphasized that while the term manifest hardship is undefined, it is difficult to see how being unable to provide for one's own basic needs, such as food, shelter, and basic medical expenses, does not meet the standard. The court also noted that courts can and should use GR 34 as a guide for determining whether somebody has an ability to pay costs. But I think it's a good thing for administrative law to keep in the back of their mind that the Supreme Court has weighed in on. What the court also said is if you impose a low payment amount, monthly payment amount on somebody that owes a large fine, and they don't have the money to pay it, essentially you're kind of destined them to have a payment into perpetuity. And the court said that was wrong. You can't impose a low monthly payment amount on a large fine amount, especially on somebody that doesn't have the income to make their own basic subsistence. And then finally, the court also pointed out that the anti-attachment provision of federal law 42 U.S.C. 407 prevented courts from imposing LFO payments on Social Security payments. You couldn't attach to a Social Security payment. That's a federal law. So, and what happened here is the lower court, the district court, also was kind of calling into question, is this person really disabled? And what the court affirmatively said pretty emphatically is that if somebody has a designation from the Social Security Administration that they're disabled, the lower courts and the state governments don't have the right to question that. They're disabled. That's what the court said. What time are we at? That's good. Number 5 I want to talk about is on page 24. It's Whatcom County versus Western Washington Growth Management Hearings Board. Now you might know this is coming out. I saw some CLEs recently where they're going to be talking about this case. It's also called the Hearst case in some realms, environmental land use realms. But I know on Lexis it's called Whatcom County versus whatever. In its own development ordinance, Whatcom County added DOE's regulations to allow a subdivision or building permit. Basically, what they allowed was anybody could hook up to permit exempt wells based on the county's reliance on the NAA rule, which is a DOE regulation. So essentially what the county was doing was, under the Growth Management Act, was kind of shirking their responsibility, is what the court said, and relying on the DOE regulation to say, well, we have enough water in our county to issue building permits out in the rural part of Whatcom County, where I used to live, actually. I grew up there. So there's a lot of permit exempt wells out there. And what Justice Wiggins, in his majority opinion, he indicated that the primary issue on appeal concerned actions local governments must take to ensure water availability under the GMA. The court observed that the county's position, and this is joined by 4 other justices too, so we essentially have a 5-person lead opinion from Justice Wiggins. The court observed that the county's position that water is presumptively available, since the county delegated the decision on water ability, like I said, to DOE's NAA rule, which is WAC Chapter 173-501. Both parties agreed that the requirements established by the rule were inapplicable to permit exempt wells in the county. Therefore, the county argued that its comprehensive plan complied with GMA requirements because water was presumptively available in the county for permit exempt wells per the DOE's NAA rule, regulation WAC. The court rejected this argument, concluding that one rule that came out of the case was GMA places an independent responsibilities on counties, not DOE, to ensure water availability. To the extent there was a conflict between the NAA rule and the later enacted Growth Management Act, the latter controlled, the court held that the board properly concluded the GMA, this is the Growth Management Hearings Board, properly concluded the Growth Management Act required counties to make determinations of water availability on their own. The court also held that the GMA requires an applicant for a building permit for a single-family residence or development to provide proof that water is both legally and actually available. This is actually going to be a big thing going forward. I think there's going to be litigation over this too, but you could see where in some of the dissents and concurring opinions here, they're worried about the burden falling on the permit, the person that's trying to acquire the permit, the residential builder, if the county doesn't do their job. The court stated that the GMA provisions would be superfluous if the county's own obligation was to defer to DOE's water regulations. Justice Madsen, in her concurring opinion, wanted to make it clear that statutes such as the GMA only expect the burden to fall on individual applicants only when the state, county, and state do not meet their statutory duties. But you can see that could possibly happen, and then you have essentially no building permits being issued in Whatcom County or other small counties or rural counties. Justice Stevens' dissenting opinion, which 2 other justices joined, the rule from that, I gathered from that, was requiring counties to make their own determination of water availability rather than relying on DOE. She believed undermined the comprehensive water management required by the Water Rights Act, another statute, RCW Chapter 90.54, different than the Growth Management Act, and pushed an insurmountable burden, as she put it, onto individuals applying for a building permit. So there's some discontent there. Another case where the Supreme Court was kind of discombobulated, divided, different opinions on how the law kind of played out. But I think there'll be more litigation on that case going forward. Next case I have is number 6, Providence Physician Services Company versus Department of Health. Page 27 of your materials. Providence built a large medical facility in Spokane. They owned a subsidiary, or through a sub, they owned another company called PPSC, which was basically a conglomerate of 27 different surgeons. They want to take advantage of a Department of Health exemption in their regulation called the ASF exemption, which is ambulatory surgical facility exemption. The key rule out of this case, in applying the definition of, basically, in response to PPSC's argument that DOH's interpretation amounted to a rule subject to the formal rulemaking procedures of the APA, the court concluded. Now, essentially what's happening here is PPSC saying, DOH, you're adding other requirements to a rule that are not written in the rule, or that you should have done formal rulemaking on the requirements you're adding to our application. And if the court said that it was not a rule, in applying the definition of rule in 34.05.010 sub 16, courts in the state have repeatedly held that agencies are empowered to interpret a statute or regulation without going through formal rulemaking procedures. An otherwise broad interpretation of a rule would serve as a straitjacket of administrative action. This is what the majority opinion said. This is known as Failer's pharmacy rule. So basically, the Failer's pharmacy rule says if an agency adds a new requirement to an already well-defined regulation, the court will deem it a rule subject to formal rulemaking. So I thought that was an important takeaway from the case. I never heard about this concept before. It's a former Supreme Court case, Failer's Pharmacy. But it's described there, and I think the site for Failer's Pharmacy is in the summary that we have in our materials. The court emphasized that DOH exercised its interpretive authority to give meaning to the existing language of the ASF exemption, i.e. the WAC, and did not engage in rulemaking. That's essentially what they said. The next case I want to talk about is Arishi, a very important case for APA purposes, people that practice in the APA realm, especially an impact on OAH, because I think they're getting more business now from especially from Washington State University on student conduct, which I think Professor Meyer talked about earlier. Arishi is page 30 of your materials. This is a Division III case. Basically what the court said, the key takeaways from that case, this is a case where you had a graduate student that was charged criminally with raping an underage girl. He thought she was 16, but she was actually 15. Basically, he was a graduate student, a PhD student. The Washington State University expelled him until 2020. And he went to a 1-hour student conduct hearing that they deemed to be a BAP under their own WACs. They deemed them to be brief adjudicated proceedings. He vehemently, on a couple occasions, asked for a full adjudication under the APA. They denied him that right, and it denied him that opportunity. Essentially, he had a 1-hour student conduct hearing. His attorney that showed up couldn't ask any questions of the witnesses. He couldn't submit any evidence unless he could only submit questions through the people that were deciding his case. Only if they decided to ask the question he submitted to them would his question be asked. And essentially, they expelled him. And he petitioned the Superior Court for review, which affirmed WSU's decision. In the case, the court noted that, I think this is an important case for people that do APA because it noted that RCW 34054821D prevents agencies from using a BAP if the issue and interest involved in a controversy warrant the use of full adjudication under the APA. the court concluded that an issue may warrant full adjudication where the nature of disputed facts and the character of the relevant evidence make the trial-like elements of full adjudication valuable safeguards against the risk, I'm reading from the case, against the risk of erroneous deprivation, where the severity of deprivation, for instance, its length, resulting stigma like being expelled from school as a graduate student, or impact on a person's life or liberty, justify additional safeguards for the individual affected. So you can see here, if you're being expelled from school, you're not allowed to continue your graduate studies. Probably that's a pretty serious moment in your life. You probably need a full adjudication. The court basically said WSU was erred in not giving him a full adjudication. And the court also noted that WSU erred in assuming the court's task was to decide whether a hybrid process, somewhere between BAP and full adjudication under the APA, met the minimum requirements of the concept of constitutional due process, since the APA only provides two types of adjudication. You got full adjudication and you got a BAP. But they're hybrid. They said, basically the court said, we're not going to entertain from state agencies hybrids of either BAPs or full adjudications. You do one or the other. And in this case, they felt like it needed to be a full adjudication. And then basically what ended up happening is the court remanded, Division 3 ended up remanding the matter back to WSU for a full adjudication. Next case I want to talk about is Crosswhite, page 33. Probably won't get through all the ones I want to talk about, but these are a couple of good ones. Crosswhite is basically one where the lady was cited by the Department of Social and Health Services for abusing a vulnerable adult as a caregiver. They basically said, she was found guilty of that by the DSHS. And basically, the key takeaway, what's interesting about this case, I thought, is that DSHS, I guess, has a WAC. Division 3 noted this WAC. I looked it up, it's still a WAC. Noted that ALJs and review judges in DSHS programs must first apply DSHS administrative regulations. Only if no DSHS rule applies are ALJs and review judges to decide an issue according to other legal authority and reasoning. It's been my experience, I usually start with the statutes, kind of work my way down to the regs, but I don't know, I have to hear from people at DSHS how that plays out. And I thought it was just an interesting WAC, and the court kind of emphasized that WAC. And ultimately, what the dissent's problem with this case was, the court basically ultimately decided she didn't abuse the person. They disagreed and said, no, this person didn't abuse the person she was a caregiver for. And the dissent said, how can you decide that? Because everybody that was trying, all the triers of fact before you went under the old WAC standard. They never applied the statutory standard that we've kind of articulated in our case today. And he would have remanded it back for a full adjudication. And even in that event, he said there probably wasn't. He said you can't let the abuser define what is in the best interest of their victim, and he said that's kind of what the majority did here. The next case I want to talk about kind of briefly, which time we got on? Am I in that time? Maybe 5 more minutes?
Well, we started a little late.
Okay, that's this one. Okay. The next case I want to talk about is on page 38 of your materials. It's called In the Matter of Botany Unlimited Design and Supply. Maybe I'm torturing the name, but that's what I'm calling it. It's a long name. What was interesting about this case is, this is a case where the guy got a license from the LCB, Liquor Control Board, to produce and process cannabis. Later on, they found out when he went to get his renewal for his license, the business did, that one of their key officers had a criminal history. I think it was for a guilty plea of federal court to conspiracy to manufacture more than 1,000 marijuana plants years earlier in 2007. So his renewal came up in mid-2014. Even though they granted him the license originally when he went for his renewal, they kind of took it back, essentially. What's interesting about this case is that they had this AAG from a different unit, Assistant Attorney General, a different unit that didn't necessarily specialize in LCB cases, kind of appear throughout the administrative process. And ultimately what happened is that the appellant didn't file a petition for review on the agency. They actually filed a motion for stay, which actually incorporated all the elements of what a petition for review would have. Essentially, everything you need in a petition for review is in their motion for stay. And they argued, well, our motion for stay is good enough. And what the court said is that, no, the service statute 3405-542 expressly states that a petition for review shall be served, even though the motion for stay was titled motion for stay on the pleading. They said that wasn't a petition for review, that it didn't suffice for the statute, therefore they never served a petition for review on the agency. What's interesting is that there was new legislation that was passed in 1998 that softened the requirement for service on an agency. So now, as of 1998, you can serve, what is it, 3405-542-6, you can serve on the attorney of record for the agency. And what the court said is that AAG Lee, even though there was a lot of orders in this case that said you had to serve senior AAGs and other people at the AG's office, not the guy that actually appeared and argued the case on behalf of the AG's office, the AAG that did appear and argue the case was actually a person that the litigant could serve. That would be proper service. I thought that was important to take away from that case. And basically, the court said that there was no substantial compliance argument here. If you served the wrong pleading with the wrong title, even though it had the same contents as the petition for review, you still don't get away with that. You have to serve a document called a petition for review because that's what the statute calls for. Next case is on page 40, Cougar Den versus Department of Licensing. This is an interesting case. I'm a former tax guy. I have an LLM in tax, but this is a DOL tax case, not a DOR tax case where I used to work. It's also a treaty case which gets fairly involved, the Yakima Indian Reservation. What the Yakima tribe was doing is they were going out to Oregon and they were getting fuel at the border and they were shipping it in to sell at their reservation. And then basically what the DOL tagged it with was a $3.6 million tax bill for first possession of the state of the fuel. It was basically a tax based on first possession of the state. And the court basically said, no, we disagreed, or Washington Supreme Court disagreed and said, no, the right to travel in the Yakima Indian Nation Treaty trumped any right to tax. So, and then I think Justice Fairhurst, used to be the senior AAG for the Revenue Division prior to Camp Comfort, if I'm not mistaken. I think that's right. Justice Fairhurst, I think, is a little more versant in tax. And then one other Justice Joinder said that she felt that the Washington fuel excise tax burdened trade, the first instance of wholesale possession of fuel in Washington, not the transport. So essentially what she said is she didn't see the Yakima Nation's right to travel in Article 3 of the treaty as a right to trade. So essentially she said the tax should have been allowed. It was a first right of possession. It wasn't a tax on travel, it was a tax on trade. And that's basically what Justice Fairhurst disagreed with the majority opinion. But the majority opinion disagreed with her and obviously found that the tax violated federal law, i.e. the treaty. I'll move one more case here. That's not a good time for Ellen too. The next important case, which on page 47, Department of Labor and Industry versus Christensen. I thought it was an important case to kind of bring up because it talks about, it's a good application of, this is somewhere where they got, Labor and Industries basically gave the right to these parties to install a tram on their home is only accessible via a tram. In 1992 they gave them an operating permit. In 2012 though, 20 years later, because of the safety of the tram that they found out later, L&I came along and put a red tag on it and says you gotta stop using that tram. But that was the only way of ingress or egress to their home. And it was approved by the L&I 20 years earlier. Basically, the court said that equitable estoppel applied, and I think the agency did that too. Basically, OAH, what happened is OAH granted appellant summary judgment motion for based on equitable estoppel because it was issued so many years earlier. L&I, you can't come in now and change your mind. Basically, I think Superior Court reversed OAH, and then ultimately the Court of Appeals said, no, you're wrong, Superior Court. The L&I was equitably estopped. And so they basically overturned it. And I think another case you should probably look at, I want to talk about it at nauseam here, is on page 49, Woodbury versus City of Seattle. I thought it was a very interesting read because there was a group of assistant chiefs that voted on a demotion of a certain deputy chief in the Seattle Fire Department. And basically the case was heard under the APA through some kind of statute where the authority kind of tailed it into APA at the tail end. And basically, I thought it was interesting because the chief was in the room when the people were making their decision, and he was kind of giving out statements. I don't want this particular deputy chief to continue his employment. If you read through the case, I have kind of problems with just fundamental fairness, and basically what the the Court of Appeals said is that it's okay with us how the Division I said it's okay with us how the Seattle Fire Department kind of decided the demotion of this particular individual. But I think what the problem with this case was is that the guy that was ultimately demoted also filed a whistleblower complaint because of the stuff that was going on at Seahawks games. In particular, he was trying to blow the whistle on the fact that the guy that was supposed to be inspecting, doing the inspections for the Seattle Fire Department at Seahawks games wasn't actually doing his job, and they actually, ultimately that it turned out to be true because they hadn't collected $200,000 worth of revenue for doing the inspections. The guy was just basically having fun at the football game. Ultimately, but the guy that filed the whistleblower complaint ultimately got demoted, and the court said that was okay. I thought there were some fundamental fairness issues with the case. I didn't quite understand how they said, at one point they said Chief Dean was participated very lightly in the assistant chief's discussion of the deputy chief's pros and cons. I thought that was pretty strange because they tried to make this argument that somehow the chief didn't influence his assistant chiefs in making the demotion call. And this is an APA proceeding in my mind. I don't know how the court saw that as kosher, but they didn't. So I'll let you speak now. Thanks.
So is this episodic acute stress or just acute stress? I greatly appreciated Professor Meyer's very concise explanation of where we are in the constitutional universe, which is in one way kind of nowhere. And definitely between the three branches. When we talk about administrative law, in a sense, we are almost always talking about the balance of powers or the separation of powers doctrine, this relationship among the three branches of government. And I really liked what he put at the end about, I hope I get this right, being proud to embody all three branches of government in what you do. Just a quick side note as we think about these issues. I read a couple of days ago a opinion piece online talking about the things that people are going to be watching this United States Supreme Court session term for, and one of them is, of course, to watch what new Justice Gorsuch does on a number of things. But especially of interest to me is this writer was saying that now Justice Gorsuch has made his opinion quite known in lower court opinions, that he believes that Chevron deference is a problem and it needs to be corrected, that what it does is cause the courts to abdicate their responsibility for saying what the law is. Now, I don't know if there are any cases that are up on this for this term for this, but it is something that we as administrative adjudicators might want to be watching. So speaking of the three branches of government, I'll jump right in with the Porter Law Center case. This is on page 22 if you're following along with this. In this state, you must be licensed to provide certain types of loan modification services. And the Department of Financial Institutions started an investigation of someone who apparently was offering these services, but was doing so under the name of Porter Law Center. They tried to get documents from this person. This person, Dean Porter, is licensed in the state of Ohio, doing business with an LLC out of South Carolina. And when they couldn't get the documents by request, they subpoenaed them and started seeing what the situation was. Ultimately, the situation was, as they decided it, was that he and his company were in fact offering mortgage modification services. And we're talking about a time, you might recall, when foreclosures were rampant, especially in certain parts of the West Coast. He was doing so through this, as I said, this out-of-state LLC. And when they began to press him on this, he was saying, well, I'm actually an attorney and we're just doing this as an incidental part of a bankruptcy type practice. So I'm exempt under your rules. After tracking down a few people who had been involved with him and doing its own investigation, going through a full hearing, the DFI said, no, your business is not practicing law with some sort of incidental mortgage modification services. Your business is mortgage modification services at something like $4,000 a pop. So when Mr. Porter went to appeal the DFI's final order, which was imposing close to $30,000 in restitution plus a $24,000 fine. Okay, so you're a shady lawyer from out of state and you're gonna try to wiggle out of this, so what are you gonna argue? Okay, well the clue is he's coming in and saying, well, DFI can't do this because it impinges on the Supreme Court's ability to regulate the practice of law in the state of Washington. So one of the most interesting aspects of this particular case, as it came down from the Court of Appeals, was that the Court of Appeals said, no, the application of consumer protection laws to attorneys doesn't impinge on the judiciary branch's ability to regulate the practice of law. We've talked in previous sessions of this update about the use of writs. Many of us practice under the APA or under some other regime that closely mimics the kind of procedural protections that the APA has. But there are a number of governmental organizations who don't practice under the APA or some sort of statutory regime, and they still need some way occasionally to get into court to have this reviewed. There are 4 writs that people can use. Most of us are familiar with the writ of mandamus or the writ of prohibition, but the 2 writs that are most important to administrative procedure are the statutory writ of review and the constitutional writ of review. The Ross-Kelly case is at page 43 of your materials. I won't go through it because it's a very relatively complex case, and it really has to do with the State Parks and Recreation Commission opening more land at Mount Spokane State Park to an expansion for a ski area. As you can imagine, that was opposed by a number of parties, environmental, the Spokane tribe, etc. But the reclassification of land that happened within that was it was within essentially the commissioner's discretion to do this, and so the parties were looking for some way to get some court review about what the commissioner had done for this, and they did use the constitutional writ of review. It's a very interesting case to read, but I won't go any farther into it right now. I recommend very quickly the Hood Canal Sand and Gravel case to you as a catalog of these writs, what they are, what they can be used for. Probably the takeaway from any of the writ cases is that the kinds of restrictions that we have under the APA for judicial review have counterparts in the writs. In other words, this is something that can be used but need to be used in relatively extraordinary circumstances. I'd like to move to the, I don't know if I'm pronouncing this right, if anybody knows, please correct me, but I'll say All-Sager on page 25. I think of this as another in the continuing saga of the Win cases coming out of the medical disciplinary boards at the Department of Health. Those of you who don't practice in this area might recall that some years ago, our state courts decided that due process required that for disciplinary proceedings against a medical license, you cannot rely on the preponderance of the evidence standard. It needed to be higher because of the interests involved. That spawned a number of cases over several years about, well, what kinds of licenses are this subject to this due process requirement? The court characterized disciplinary proceedings against a medical license as quasi-criminal. So this gives rise to this interesting case where the Board of Osteopathic Medicine and Surgery had sanctioned a doctor for inappropriately prescribing dangerous medications without conducting the necessary patient examinations, an issue that is much in the headlines today. So he was prohibited from prescribing Schedule II or Schedule III controlled substances, but in 2012, about 4 years after imposing the sanctions, the board received a complaint regarding his treatment of one of his patients. The investigation that ensued created the necessity to charge him, and the investigator wanted to get these files. The appellant responded by asking the board to quash the production demand on constitutional grounds. Excuse me. But as the investigation progressed, the appellant continued to respond that he was not going to produce any of the requested information based on Fourth and Fifth Amendment rights protecting him from compelled cooperation. In fact, he petitioned the board for a declaratory order that he need not testify or produce the requested records on constitutional grounds, which was also denied. Then the appellant petitioned the Superior Court for a declaratory judgment that the board couldn't require him to testify or produce these records, and the statutes imposing these requirements were facially unconstitutional. But the trial court granted the motion for summary judgment and dismissed. Ultimately, what this case came to was that in the hearing proceedings, the appellant continued to assert his Fourth and Fifth Amendment rights to the extent that he refused to testify at all. And we have this image from this case of the prosecuting staff members interrogating an empty chair. Ultimately, what came out of this was that the court said, when we got to, when we got to the Court of Appeals, was the court really had to look a little bit more at this quasi-criminal idea and to say, well, they're not really criminal. For these purposes, it's really more civil, and you can't invoke criminal protections to stymie essentially what is a civil matter. The United Airlines case is in your materials, I think primarily as an illustration about how procedure really matters in the administrative realm. United Airlines has a leasehold interest in SeaTac Airport. The question was really was the value of this leasehold interest. The Department of Revenue, actually the King County, but it ended up with the Department of Revenue. But the point was that what United Airlines failed to do was to recognize that it had two avenues to appeal the assessment of its leasehold interest, and it missed the first one. And the first one was the way that you could challenge valuation. Instead, it took the second avenue. The second avenue really is for the correction of clerical errors, that type of thing. And eventually the court just said, sorry, you took the wrong road and you are SOL. A lot of money involved in this. We have been talking about the respective roles and limits of authority, so I would just, we have not had many cases in this past couple of years with direct challenges to adoption of agency rules as we did in the years previously. I would just let you take a look at the restaurants, excuse me, the Restaurant Association case against the Liquor Control Board. The Liquor Control Board is still struggling to implement the initiative that privatized the sale of liquor in this state. A number of these trade associations have been relatively successful in getting some of the board's adopted rules trying to tame this beast thrown out. And the Restaurant Associations is just the latest. Bill said that I should talk about the Lenander versus DRS case. This was also a frontal assault on the adoption of new rules. Actually, I wasn't that involved in this case. There's an interesting procedural sideline in this case, in that this was a APA petition for declaratory order, which is the standard way that you do this in Superior Court. The attorney handling this matter sensed that he was not making headway with the court as various procedural rulings and limits on evidence were entered. So he presented the court with an order to have this remanded to the agency, and I don't think they even used the term remand. They said the agency should take a look at this and adjudicate this fellow's right to a benefit. So a little bit of background. This case arises out of the Washington State Patrol Retirement System, Plan 1. So this is a trooper who has been in service for a number of years, and the law enforcement systems, which are venerable, have statutory surviving spouse benefits that you would guess came out of the 1940s. If the person retires and their spouse survives them, there's only going to be one spouse, right? And she is only going to need half of his retirement. It's always a him. And so that's what the statute provided, but there was no COLA. So in 1999, the legislature said we need to do a better job. DRS, you adopt rules to make it possible for people retiring to have a different choice where they can provide their spouse with a lifetime survivor benefit, but it comes with a cost. You have to reduce your benefit because it all has to be actuarially equivalent. This fellow retired. The department did so. They had a 3% reduction. They changed that after getting input from the state actuary's office saying that isn't a very good way to do your actuarial equivalence. He got essentially caught by when he retired. So the reduction in his benefit went from 3% to 5.3%. Now the Troopers Association is involved in this, as you might imagine. In any case, when the department changed its rules to more finely tune the actuarial reduction, he came back and said, well, this is, they don't have the statutory authority to do this, and it's a violation, it's a constitutional violation of his rights. So the what I did, given the remand to me, was basically go through an APA analysis. I said I couldn't do anything other than adjudicate his benefit. We already knew what all the facts were, and that particular calculation was okay. When the court came to look at the agency's authority to change those rules, it did it in two different phases. One was to look at the agency's authority overall, and this really brought in the relationship between this agency, DRS, the state actuary's office, and the legislature, and said, well, the legislature really intends for this to not be static. Also, more specifically, it looked at the grant of authority to the agency by that particular statute in 1999 and indicated that what we were after here was actuarial equivalence, and that's what the new rules did. So they weren't invalid on that. Was the agency had the authority, and they weren't valid on that ground either. And the last ground, being the constitutional challenge, was the constitutional expectation in your pension benefit, if you work for any of the organizations that participate in these retirement systems, is to your benefit under the legal regime at the time that you begin your employment. What the court said was maintaining this actuarial equivalence meant that any changes that the department was doing essentially were neutral. They didn't take anything away. They didn't really change anything, despite the result in his particular case. Over his lifetime, the intention was for this all to be neutral. So the court turned away that challenge. I would like to mention briefly the Narrows real estate case. This has to do with the ALJ's ability to fashion a remedy. Now this, for those of you who work in regulatory areas where there are sanctions, fines, that sort of thing, you know that it can be a bit of a difficulty when a case comes to you. The agency has already designated some kind of a sanction, but after you've gone through your whole process, there's a big question in your mind as to whether that sanction is okay. I know we wrestled with this at the DRS Board of Appeals, and in this case, after reviewing the whole evidentiary record that had been developed around, this has to do with water charges in a mobile home park. This is something that is administered, there are state statutes, but it's administered through the AG's office. But after looking at all of this, the program at the AG's office had imposed a certain penalty on the operator of this mobile home park. By the time the ALJ had gone through all the evidence and listened to this, the ALJ upheld the fact that a sanction should be imposed, but more than doubled the sanction. And the courts really came back with this and said, that's not really within your authority. The only authority that you really have is to look and see if the record that you create supports the the sanction that the agency has proposed. So I think with that, we are come to the end of this. I just returned from the conference from the National Association of Hearing Officials, and one of the presenters there said he had never presented to an audience that listened like that. I said, duh. So thank you for being good listeners.